governance in the Philippines. As we learn the basic concept and the evolution of human rights from the early period to the modern times, this is the Mabuhay History Vlog, your guide to the discussion of the various human rights instruments ratified by the Philippines as a signatory to the Universal Declaration of Human Rights. Lesson 1. The International Conventions on Human Rights. We have journeyed back to the historical antecedents of human rights as a principle and concept. Today, in this particular topic, we will have a brief discussion about the various international conventions as the enumerated by the OHCHR, or the UN Human Rights Office of the High Commissioner. International Convention on the Elimination of All Forms of Racial Discrimination, ICERD. On December 21, 1965, the ICERD has been adopted. This commits that all state parties to eliminate all forms of racial discrimination and to promote understanding among all races. This aims to take action on eliminating racial discrimination in all its forms, including eradicating racial hatred and incitement to hatred. International Covenant on Civil and Political Rights, ICCPR. On December 16, 1966, the ICCPR has been adopted. In this convention, this states that by virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development. The ICCPR recognizes the inherent dignity of each individual and undertakes to promote conditions within states to allow the enjoyment of civil and political rights. International Covenant on Economic, Social, and Cultural Rights, ICESCR. On the same day, the ICESCR has been adopted too. This aims that the states parties to the present covenant undertake to ensure the equal right of men and women to the enjoyment of all economic, social, and cultural rights set forth in the present covenant. Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW. On December 18, 1979, the CEDAW has been adopted. It is an international legal instrument that requires countries to eliminate discrimination against women and girls in all areas and promotes women's and girls' equal rights. The CEDAW Convention is built on three foundational principles: non-discrimination, state obligation, and substantive equality. Non-discrimination is integral to the concept of equality. Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment, CAT. On December 10, 1984, the CAT has been adopted. This was anchored on the Universal Declaration of Human Rights and the ICCPR. It upholds that no one shall be subjected to torture or to cruel, inhuman, or degrading treatment or punishment. All persons deprived of their liberty shall be treated with the respect for the inherent dignity of the human person. This requires the signatory parties to take measures to end torture within their territorial jurisdiction and to criminalize all acts of torture.
And then there are the other international conventions. The Convention on the Rights of the Child, CRC. On November 20, 1989, the CRC has been adopted. CRC protects the rights of the children in all areas of their life, including the right to life, survival, and development, freedom from violence, abuse, and neglect, express their views in matters affecting them, including in legal proceedings. The International Convention on the Protection of the Rights of All Migrant Workers and Members of Their Families, ICMW. On December 19, 1990, ICMW has been adopted. ICMW is a global diplomatic deal to guarantee dignity and equality in an era of globalization. The convention sets minimum standards for migrant workers and members of their families, with a focus on eliminating the exploitation of workers in the migration process. Convention on the Rights of Persons with Disabilities, CRPD. Lastly, on December 13, 2006, CRPD has been adopted. CRPD aims to promote, protect, and ensure the full and equal enjoyment of all human rights and fundamental freedoms by all persons with disabilities, and to promote respect for their inherent dignity. International Convention for the Protection of All Persons from Enforced Disappearance, CPED. In the contrary of ICMW, on December 20 of the same year, the CPED has been adopted. CPED compels states to fight enforced disappearance on their respective territories. In particular, it affirms the right of individuals to know the fate of their disappeared relatives and to obtain justice and reparation. And now, here are some optional protocols. Aside from the main treaties, there are optional protocols that aim to complement or supplement the existing ones. December 16, 1966, Optional Protocol to the International Covenant on Civil and Political Rights. December 15, 1989, Second Optional Protocol to the International Covenant on Civil and Political Rights, aiming at the abolition of death penalty. December 10, 1999, Optional Protocol to the Convention on the Elimination of Discriminations Against Women. May 25, 2000, Optional Protocol to the Convention on the Rights of the Child on the Involvement of Children in Armed Conflict. May 25, 2000, Optional Protocol to the Convention on the Rights of the Child on the Sale of Children, Child Prostitution, and Child Pornography. April 14, 2014, Optional Protocol to the Convention on the Rights of the Child on a Communications Procedure. December 18, 2002, Optional Protocol to the Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment. December 12, 2006, Optional Protocol to the Convention on the Rights of Persons with Disabilities. The following are lists of general international human rights instruments. Universal Declaration of Human Rights, 1948. International Convention on the Elimination of All Forms of Racial Discrimination, 1965. International Covenant on Civil and Political Rights, 1966. International Covenant on Economic, Social, and Cultural Rights, 1966. United Nations Convention on the Elimination of All Forms of Discrimination Against Women, 1979. United Nations Convention on the Rights of the Child, 1989. United Nations Convention on the Rights of Persons with Disabilities, 2006. European Convention on Human Rights, 1950. European Social Charter, 1961. Charter of Fundamental Rights of European Union, 2000. As a summary of the things discussed, wherever we are, there are rights that protects our humanity. The international conventions that was mentioned only show what nations around them as valuable ensuring these rights.
So we here to talk about Lesson 2, the National Human Rights Institution and the Forest Principle. In this topic, we will be having a brief discussion about two topics that are related to the human rights governance in the Philippines. So, before we begin, I expected this topic to be understandable and knowledgeable. But before we get that far, let me explain what National Human Rights Institution are and what are of this organization play in our society. National Human Rights Institution. A national human rights institution is an independent state-based organization tasked with broadly protecting and promoting human rights in given country. And there are two functions of rules. So, in this topic, the rules of promotion and protection are as follows. Promotion and protection. Promotion. of a national culture of human rights based on tolerance and equality in order to foster an enable environment in society. Protection which assists in identifying and investigating life experiences of abuses in order to address the issue, and protects human rights. This is decision of Parliament, both nation and national, based on legal decision in human rights. The national human rights decision was to support the individual, society, and government organization. The role of national human rights institution. The role of national human rights institution is to guide and serve the legislation, policy, and program that advocate for human rights. Will play a minor role in promoting and monitoring a national human rights system, effective implementation. Purpose of establishing national human rights. The reason for this is that every country has experienced many conflicts involving serious human rights violations. National governments desire to establish institutions that reflected each individual's opinion and cultural background. So, in the year 1992, the government promotes the institution, and in the year of the 20th century, the national was involved to provide the ability to promote equal treatment and useful things that can be used to address the issue. Okay, we are now moving on the next topic, which is the relationship between civil society and the state, as well as the national and the international level. Between civil and the state. As the state mandate bodies independent of the government, NHRIs sit between the state and the civil society. NHRIs cooperate with a variety of civil society actors and bring an accurate overview of human rights situation with the recommendation of the government parliament. Between the national and international. CNHR apply international human rights standard at the nation level with a full understanding of the local context. At the same time, they report the international and regional human rights mechanism, a true pictures of the human rights situation on the ground. National human rights in the Philippines. The Philippines Constitution of 1987 primary change CHR with protecting and promoting the rights and dignity of all people in the country. The state respects the dignity of every human being and ensure that human rights are fully respected. Current state of the human rights in the Philippines. Now, let's proceed to the current state of Philippines human rights, which were establishing in the Philippines on May 5, 1987, under the leadership of Jose Wright Jokno, a Filipino nationalist, lawyer, and statesman, regarded as the father of the human rights advocacy in the Philippines. President Ferdinand Marcos signed Decree number 2036 on February 20, 1986, establishing the Commission on Human Rights. This decree, however, was not carried out because Marcos fled to the United Nations. On March 18, 1987, Corazon Aquino, who had been replaced during the EDSA People Power Revolution, signed Executive Number 8, established the Presidential Committee of the Human Rights by virtue of the Aquino of Freedom Constitution. We know that Ferdinand Marcos violated human rights in the 1970s and 1980s, and the military units were involved in human rights violation during Marcos' dictatorship. In May 5, President Aquino signed Executive Order number 163. The commission was established as the independent office tasked with investigating violation of people's rights, including civil and political rights. In the current situation, the commission mandate was brought by the Philippines Constitution to include the human rights protection, human rights promotion, and human rights policy. However, In Duterte administration, certain rules had been violated. For example, in the war on drugs, there had been murder in rural areas, with poor or low-income people being killed. Disclaimer: this topic is solely for educational purposes. Thousands of people had died as a result of extrajudicial killing during the Duterte administration. And now, we will discuss the 6 functions and types of NHRIs, which are the Human Rights Commission, Human Rights Ombudsman, hybrid institution, consultative and advocacy bodies, lastly, multiple rights. Type and function. 1. Human Rights Commission. This NHRIs is frequently concerned with abuses committed by individuals, groups, or government. The next one, Human Rights Ombudsman. This NHRIs is frequently concerned with abuses committed by public official or institution. 3. Hybrid institution. This is when a Human Rights Commission also serves as the Ombudsman Commission. 4th, consultative and advisory body. This is primarily concerned with providing legal advice to improve human rights protection. Institution and center. These are organizations that provide assistance, conduct research, and implemented human rights education for a specific marginalization of vulnerable groups. And lastly, multiple institutions. Human rights protects and promote are sometimes made possible through the collaboration of several constitutions.
The Paris Principles. 25 years after the international community first formally embraced the idea of creating national institutions for the promotion and protection of human rights through the endorsement of the Paris Principles, it is obvious that independent and effective national human rights institutions are every bit as important and relevant today. On 20 December 1993, the UN General Assembly adopted Resolution 48/134 on national institutions for the promotion and protection of human rights, with an annex containing the principles relating to the status of national institutions, better known as the Paris Principles, in which it encouraged all states in the world to set up independent national human rights institutions, NHRIS. NHRIS are non-judicial, independent institutions created by the states through their constitution or law, with the mandate to promote and protect human rights. States are free to decide the best type of NHRI for their domestic purposes. In Europe, the most common models are Ombudsman institution, Human Rights Commission, hybrid institution, which combine several mandates including that of equality body and human rights institution and centers. NHRIS are uniquely placed to hold governments to account and advance human rights. A state-created and state-funded institution, they enjoy special legitimacy and access to policy makers. At the same time, they are mandated to cooperate closely with civil society. They can thus act as a bridge between civil society and the authorities, while at the same time being independent from both. As local actors, NHRIS have a deep understanding of the domestic context and the conduct persistent advocacy for change. Not all NHRIS are fully effective and independent, but those that comply with the Paris Principle have become increasingly recognized as crucial actors within the global human rights framework.
Lesson 3. Human Rights in Philippine Law Enforcement. The study of human rights goes hand in hand with the law enforcement in that every person, whether accused of a crime or not, is entitled to respect and dignity. The connection of the study of human rights to law enforcement activities is to regulate the movement of law enforcement agents to through our human right-based approach in dealing with arrested person, detainees, and other similar stakeholders. Article 1 of the Universal Declaration of Human Rights provides that all human beings are born free and equal in dignity and rights. Individual obligation and human rights. All human rights, regardless of category, are indivisible and interdependent. Realizing one right is essential condition or instrumental in realizing other rights, such as the right of the suspect as enshrined and guaranteed by no less than the Constitution. The protection of human rights is continually observed and subject to very defined exceptions. It is essentially a matter of learning and understanding the basic human rights of a person and acting in accordance with those rights in dealing with every individual, whether the law enforcement side or citizen side. State obligation and human rights. Obligation to respect human rights is to refrain from illegal disproportionate action, avoid unjustified interferences such as the right to privacy and the sanctity of a home. The utmost cooperation of the person arrested must be expected so as not to hamper the effective performance of the duties of the law enforcement officer or arresting officer. Obligation to protect human rights is to take executive, legislative, and judicial action to ensure human rights of every human being, such as the right of a person arrested and under custodial investigation under the Republic Act No. 7438, in which the state must come up with laws to protect its citizens from hampering their human rights, such as the right to speedy disposition of their criminal cases. The Supreme Court ruling on inordinate delaying as well as the right to bail whenever a person is lawfully arrested without a warrant of arrest. These rules are all enshrined by no less than the 1987 Constitution. Obligation to fulfill human rights means that the state must take positive action to facilitate the enjoyment of basic human rights. In law enforcement, a classic example of the government obligation to fulfill is the treatment of children in conflict with the law under the Republic Act No. 9344. Where a child involved in a crime should not be treated similarly with other persons who belong to the age of majority. Police obligation and human rights. When a police officer arrests a suspect, he or she is interference with that suspect's human rights to personal liberty and security. The basis for interfering or deprivation of liberty brought about by arrest is to protect the life of others or to enforce the law, but at all times, it must have basis in law. Police includes all law enforcement officials who conduct arrests under Rule 113 of the Rules of Court, particularly Section 5, Rule 113 on warrantless arrest. Section 5. Arrest without warrant when lawful a police officer or a private person may without a warrant. A. When the presence of the person does actually committed a crime or attempt to commit a crime. B. When an offense has been committed and has been probable cause based on a personal knowledge of facts. C. When a person to be arrested is a prisoner who escaped from a penal establishment or a place where he or she is serving final judgment.
Characteristics of human rights. Internationally guaranteed. Legally protected. Focus on the dignity of the human being. Protect individuals in group. Oblige the state and the state actors. Cannot be waived or taken away. Equal and interdependent. Universal. Who makes the human rights rules? Human rights rules are made by the international legal system as outlined in the Charter of the United Nations. It is built around the community of the states. It is the states themselves who make the rules through the development of custom, the development of treaties, and the development of international declaration, guidelines, and bodies of principles. Venue of rules on human rights. Human rights standards are developed and codified in various international forums through a process where a representative of a state member of those forums meet, usually repeated over a period of years, to work out the form and content of international human rights instruments. article by article and line by line. Regional organizations have developed mechanisms to monitor human rights within the relevant countries, such as mechanisms includes the Inner American Commission on Human Rights, the Inner American Court of Human Rights, the African Commission of Human and People's Rights, the European Commission of Human Rights, and the European Court of Human Rights, and the Committee of Ministers of the Councils of Europe. List of General International Human Rights. Universal Declaration of Human Rights on 1948. International Convention on the Elimination of All Forms of Racial Discrimination on 1965. International Covenant on Civil and Political Rights on 1966. International Covenant on Economic, Social and Cultural Rights on 1966. United Nations Convention on the Elimination of All Forms of Discrimination against Women on 1979. United Nations Convention on the Rights of the Child on 1989. United Nations Convention on the Rights of Persons with Disabilities on 2006. European Convention on Human Rights on 1950. European Social Charter on 1961, Charter of Fundamental Rights on the European Union on 2000. Selected international human rights for law enforcement officials. UN Convention Against Torture and Other Cruel, Inhuman, and Degrading Treatment or Punishment on 1984. Optional Protocol to the UN Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment on 2002. European Convention for the Prevention of Torture and Inhuman or Degrading Treatment or Punishment on 1980. Article 1 of the Convention Against Torture provides that every human being must be protected against torture or act that causes pain. On the other hand, cruel, inhuman, or degrading punishment that do not amount to torture as defined in Article 1. International Convention for the Protection of All Persons Enforced Disappearance on 2006, the purpose of the convention is to raise awareness of the extreme seriousness of enforced disappearance. UN Code of Conduct for Law Enforcement Officials on 1979. UN Declaration of Basic Principles of Justice for Victims of Crime and Abuse of Power on 1985. UN Basis Principles on the Use of Force and Firearms by Law Enforcement Officials on 1990. Councils of Europe Declaration, the Police 1979. Council of European Code of Police Ethics on 2001. Law enforcement officials must be the frontliners implementing human rights instrument by spreading respect and protection for human dignity. The Philippine Commission on Human Rights. The Commission on Human Rights is an independent national rights institution created under the 1987 Philippines Constitution established on May 15, 1987. By virtue of Executive Order No. 163, the Commission is mandated to conduct investigation on human rights violation against marginalized and vulnerable sectors of the society involving civil and political rights. Constitutional basis on the creation of the Commission on Human Rights. The Commission on Human Rights was created as a response to the atrocities committed during martial law. When the 1987 Constitution was dropped, Article 13 on Social Justice and Human Rights defined the creation of the Commission.
Section 1 of Article 13 of the 1987 Constitution mandates the Congress to give the highest priority to the enhancement of measures that protect and enhance the right of all people to human dignity, reduce social, economic, and political inequalities, and remove cultural inequalities by equitably diffusing wealth and political power for the common good. Section 17 and 18 of Article 3 of the 1987 Constitution provide for the creation of an independent office called the Commission on Human Rights and defines its power and functions. The same power and functions of the Commission on Human Rights are defined under Section 3 of Executive Order Number 163, Section 11, Article 2 of the 1987 Constitution provides that the state value the dignity of every human person and guarantees full respect for human rights.
Now, let's tackle the non-discrimination law enforcement. As per the human rights in the Philippine national law enforcement, police should not unlawfully discriminate anyone with regards to their race, gender, religion, language, color, political opinion, national or ethnic origin, birth or other status. For in the first place, police are meant to protect and serve community as well as in the police application, recruitment, hiring and assignment and promotion policies. There should be no discrimination at all times. In addition, there is a special measure given for the women, child, juveniles, PWD, elderly, and other group of requiring special treatment in accordance with international human rights standard. Now, in the conducting the police investigation, everyone should be treated fairly. The witness, private, complainant, and as well as the accused, and he presumed as innocent until proven guilty by the court. For the human rights to security is the focal issue. Therefore, they should be free from cruelty, inhuman, and degrading punishment, even when they are already convicted. But first, the criminal investigation should remain confidential together with the evidence, scientific recovery, and possible witnesses. Moreover, sexually abuse against minors or children in conflict with the law are subject to confidentiality of information. Now let's move forward. The silent rules on investigation in consonance with human rights. What are those? First, it should be not unduly arbitrary, unduly intrusive, or biased. Second, it should be confidential, prompt, impartial, and lawful. Then third, it should include careful processing of crime scene. And lastly, it should seek to collect and preserve evidence. So, wrap it up. It tells that all police activities relating to collection of evidence and criminal investigation should be conducted only according to the law with due cause and within respect for human rights and fundamental freedoms. But wait, there are more. There are also 8 human rights of arrested person. First is prohibition of arbitrary arrest. Second, right to inform of reason at the time of arrest. Third, the right of promptly informed of the charge. Fourth, right to be brought promptly to proper authorities for disposition. Fifth is right to access to lawyer. Sixth, right to interpreter when necessary. 7, right to bail. And the last, number 8, is right to notify family of his or her withdrawals. So, an arbitrary arrest and detention is considered as deprivation of liberty without lawful reasons or due process. So, if police officer is using his or her authority in arresting human being in the absence of legal grounds and legal procedure, the arrest is not reasonable and inappropriate in the given of circumstances. And now let's differentiate the detainees and the prisoners. And a detainee is a person deprived of the liberty by means other than conviction. However, a prisoner is deprived of the liberty as a result of conviction of an offense. But remember, one detainee is not only because of the lawful cause, but also for some medical issue, and detainee still enjoys the presumption of innocence. Therefore, they should be from any form of violence and threats. Likewise, the arrested person should be free from degrading treatment. inside the detention facility. However, women and juveniles are separated from any ordinary detainees. So, the jail management should impose measures of discipline that are reasonable and consistent with the law and regulation. So, even you are detainee or a prisoner, it those means that anyone are already allowed to not to treat you as you well. It's wrong mindset because you should still be treated humanely, especially when in the facilities for detention. It has a compliant with the basic health standard and not congested for hygiene reason. Then the jail official must be also provide a medical service, opportunity for recreation, earning as well as to allow you to freely practice your religion and moral beliefs. And of course, jail visitation is a proper communication should not be deprived to detainee or prisoner. And now let's hop into the use of force and firearms by the law enforcement. A law enforcer must be bear in the mind that his primary responsibility to enforce the law and maintain order. That the law enforcer must be exercise the powers of lawfully and effectively. Therefore, the use of force is strictly regulated by the law and must follow the clear police guidelines and procedure. It is form of violation of human right. If you do so necessary, proportionately, legally, and accountability should be considered, and as much as possible, damage or injury must be minimized. On the other hand, the use of firearms should be carefully managed as well. A law enforcer has to think twice or thoroughly. It is considered the reason to use it, and he or she should not allow his emotion or ignorance to dictate him what action we take. Firearm must be only used as the self-defense or in order to protect human life in the imminent threats or extreme circumstances. So, before the use of firearms, the law enforcer must be identifying himself or herself as the police official and must give a clear warning and provide the person enough time to obey unless delay should not cause of death or injury to the police officer or else in the appropriate under the given circumstances. However, if police officer fired a shot, it is mandatory to render an initial medical aid to all injured and call an emergency medical assistant and notify all the relatives of person shot and allow to investigation if required or requested. Lastly, the law enforcer must prepare a full detailed report about the incident. Let's now discuss the juveniles, children in the conflict with the law or children at a risk. There is a need to train the law enforcer in handling cases involving children in our existing law. There is variety of disposing that are available to children. What are those? First, the intervention with a law family and other support group to deal with the children in the less serious case. Second, in the diversion, it resorted to for the purpose of avoiding children in the criminal justice system and redirecting children to community support system. However, but both foster care, guidance, and supervisor order that are undertaken by the parents. Meanwhile, children that are product of cruelty, society, and misfortune has to be given attention to, for they are considered children at risk. Now, with regards to all women, may it be offender, victim, or law enforcer. The protection of human rights standard must always be observed. They should be free from sexual abuse and special treatment to pregnant women are given. For women offender, a female law enforcer, a counterpart is the one who ought to be at contact. Women offender must also segregated from the male detainees. Then, for the woman victim, it also be given a prompt address to issue the same way how law officers promptly address any crimes and complaints or issue arising. Did you know what a violence against women? It is any means to act of resulting to physical, sexual, or psychological harm or suffering to women. However, there are two types of violence that women victims suffer. Let's elaborate the two so you can be aware and be attentive. First, the family-related violence, which happen technically inside the household. This includes marital rape. Then the other one is a community-related violence, which means pertain to the violence that women may get to experience around their social environment, like at work, educational institution, or public place. It includes sexual harassment, intimidation at work, trafficking, and forced prostitution. Meanwhile, female law enforcers are also entitled for standard of human rights. There must no gender bias, and it's discouraged to create gender incentives. Conversation and joke. Next, let's tackle what's right those refugees and non-national has. With this, there are 11 international standards for refugees. Here are those. Everyone has right to seek and enjoy in another country asylum from persecution. 2. Refugees are entitled all basic human rights, with the exception of certain political rights, but if they unlawfully within the territory, certain limitation on movement may apply in interest of public order and health. 3. Refugees should be granted treatment, which it is listed as favorable as that granted to nationals in the exercise of basic rights such as freedom of association, freedom of religion, access to elementary education, public relief, access to courts, property rights, and housing. 4. No one shall be returned to country in which his or her life or freedom will be threatened or where he or she would be persecuted or to a third country, likely to return a refugee to such a country. 5. Refugees unlawfully within the territory of a state who have come directly from a country of persecution and who present themselves without delay to the authorities should not be penalized. 6. Refugees are coming directly from a country of persecution should not be refused as place a temporary entry. 7. Refugees lawfully in the territory of the state have the right to freedom of movement and residence. 9. Refugees lawfully within the territory shall not granted travel, document, and identify flight. 10. Person to seeking asylum shall be informed of the necessary procedure, provide with the necessary facilities to do so, and allowed to remain pending final decision. No refugee 11. No refugee shall expelled except on the grounds of national security or the public order, and only on the basis of decision, which in accordance with due process of law. The last, before expulsion, refugees shall be given an opportunity to offer evidence, to represented, and to appeal to a higher authority. However, there are 12 international standards for non-nationals. 1. Nationals include foreigner and stateless person. 2. Non-nationals are lawfully within the territory if they have entered in accordance with the legal system or if they possess a valid residence permit. 3. Non-national lawfully within the territory are entitled to all human rights except certain political rights. 4. Non-national have the same right to live and emigrate as nationals. 5. National lawfully within the territory who have close attached to the state and view it as their own. 6. Other non-national lawfully within the territory may be expelled only if decided by law, if the decision is not arbitrary or discriminatory, and if procedural guarantees have been afforded. 7. Procedural guarantees for exclusion include the right to be heard, the right to be reviewed by competent authority, the right to representation, and the right to appeal to higher authority, the right to enjoyment of full facilities to pursue a remedy, the right to remain pending and appeal, and the right to inform of available of remedies. 8. Exception for the procedural guarantees may be allowed but only for compelling reason of national security, such as political or military threats to the whole nation. 9. Collective or mass exclusions are prohibited. 10. Disputes on the minor dependent children or of a non-national lawfully in the territory must be admitted to join the non-national. 11. All non-national must be free to communicate with their consulate or diplomatic mission. The last, 12. Non-national who are expelled should be permitted to depart to any country that accepts them, and many may not be sent to a country where their human rights will be violated. Lastly, let's talk about the guidelines for law enforcer. Be alert to any evidence of xenophobic or racist activity in your duty area. Cooperate closely with immigration authorities and social agencies assisting refugees and non-national in area within high immigrant concentration. Reassure residents of their rights to seek a police protection and assistance without fear of being deported. Remind colleges that the unlawfully present non-national are not criminals or not criminal suspects solely by the virtue of their immigration status. Provide a visible security for refugees, shelter, and camps. Issue clear order on the special vulnerability and protective needs of refugees and non-nationals. Develop the cooperative scheme with community representatives to combat racism and xenophobic violence and intimidation. Organize the foot patrols for area of high refugees concentration and consider establish the police substation in the such area. Establish a special unit with the necessary legal training, linguistic skill, and social skill to work with terms of reference, focusing on protection rather than on enforcement of immigration law. Police agencies charged with border control and immigration law. Law enforcement shall provide a specialized in training in the risk of refugees and non-national and it the procedural guarantees afford to such a group. Liaise closely with the social agency providing support and service refugees and non-national it needs.
For the last of lesson 3, I will say all guidelines for law enforcement. A. Be alert to any evidence of xenophobic or racist activity in your duty area. B. Cooperate closely with immigration authorities and social agencies assisting refugees and non-nationals. C. In areas with high immigrant concentrations, reassure residents for their rights to seek police protection and assistance without fear of being deported. D. Remind colleges that unlawfully present non-nationals are not criminals or criminal suspects solely by virtue of their immigration status. E. Provide visible security of refugee shelters and camps. F. Issue clear order on the special vulnerability and protective needs of refugees and non-nationals. G. Develop cooperative teams with community representatives to combat racist and xenophobic violence and intimidation. H. Organize foot patrols for areas of high refugee concentration and consider establishing police substation in such area. I. Establish special units with the necessary legal training, linguistic skills, and social skills to work with their term of reference focusing protection rather than one enforcement or immigration laws. J. Police agencies charged with border control and immigration law enforcement should provide specialized training in the rights of refugees and J. Police agencies charged with border control and immigration law enforcement should provide specialized training in the rights of refugees and non-nationals and in procedural guarantees afforded to such groups. K. Liaise closely with social agencies providing support services to refugees and non-nationals indeed. And that's the guidelines for law enforcement. The next is victims. So what is the victims? There are two types of victims that may be useful in the context of human rights. One is victims of crime and the other is victims of human rights violation. So victims of crime are persons who individually or collectively have suffered harm, including physical or mental injury, emotional suffering, economic loss, or substantial impairment of their fundamental rights through acts of or omission that are in violation of criminal laws operative with the state, including laws prescribing criminal abuse of power. Human rights of victims. All victims of crime, abuse of power, or human rights violations shall be treated with compassion and respect and shall have access to mechanism of justice and prompt redress. Victims must be allowed to represent their view and feelings on all matters where their personal interests are affected. Next is the police command and management. Law enforcement officials shall at all times fulfill the duty imposed on them by law by serving the community and by protecting all persons against illegal acts consistent with the high degree of responsibility required by their profession. They shall commit any act of corruption and rigorously oppose and combat all such acts. law enforcers must maintain clear, complete, and accurate records on investigations, arrest, detention, the use of force and firearms, victim assistance, and all aspects of police and activity. As much training and clear guidelines shall be made available on all aspects of police activity affecting human rights to serve as guide in the performance of their duties. Also, police agencies must provide adequate training for the differentiated use of force and adopt proper methodologies such as, but not limited to, reporting and review by superior officials on any use of force or firearms by the law enforcement agent. Next is community policing. As an essential pillar of the criminal justice system, community policing emphasizes proactive problem solving in a systematic and routine fashion, rather than responding to crime only after it occurs. Community policing encourages agencies to proactively develop solutions to the immediate underlying conditions contributing to public safety problems. Also, the goal of community policing is to reduce crime and disorder by carefully examining the problems in neighborhoods and then applying appropriate problem-solving remedies. Next is police violation. It is the basic principle that law enforcement officials shall respect and protect human dignity and shall maintain and uphold the human right of all persons. The policies of human rights recognize this role. Public information and public dissemination through community outreach programs is recognized as a mode of reaching out to the community. The law enforcement, together with the community, must adopt a community relations policy and plan of action. By the summary of human rights, for many police are the most visible state representatives and those with whom citizens are most likely to come into contact. They therefore represent the government in action. The police may thus influence the citizens' overall opinions on and perspective of government as a whole, with their actions strengthening or weakening the public support necessary to sustain a viable. If understood in the proper context, the promotion and protection of human rights are at the very core of policing. The enforcement of laws and the maintenance of peace and order are first and foremost about protecting the right of citizens. At its best, policing is a noble undertaking, protecting, defending, reassuring, calming, and restoring the social orders as well as the dignity of individuals, victims, offenders, and the community at large. The state obligation to protect, respect, and fulfill human rights is constitutionally entrenched in furtherance of its obligation to fulfill. The Congress is duty-bound to give highest priority to the enhancement of measures that protect and enhance the right of all the people of human dignity, among others.
My name is Deline May F. Gonzalez.
My name is Pauline Sigador.
My name is Reynaldo Irinco Jr.
My name is Christopher John C. Lagaras.
My name is Angelo Ordeana.